Good afternoon, everyone. In the coming up trial of Bryan Kohberger, we were all awaiting many rulings by Judge Stephen Hippler. And not to our surprise, but to the surprise of many, Judge Stephen Hippler ruled that this case is going forward. Going forward 1 week later than was originally planned. Instead of August 11th, the trial will proceed on August the 18th. But on all the rulings that we predicted that Judge Hippler would rule in favor of the defense, he actually has ruled in the favor of the defense. And it was sort of not a huge surprise, since Judge Hippler gave several clues that he was going to lean that way. And this is the document that basically gives us the time frame, the time frame of what Judge Hippler plans. The court's prior scheduling order is amended as follows: sealed proceedings with the court and counsel will take place July 28th, 2025 through August 1st, 2025. Jury voir dire will commence on August 4th, 2025, rather than July 30th, and continue until a jury is seated. It's estimated that the trial itself, beginning with opening statements, will commence on August 18th, 2025, and continue until completed. So right there, that is saying this no-nonsense judge, the continuance is out, and we'll get into more of that later on. But this case is moving forward. As we predicted, 2.5 years is a reasonable, way more than reasonable amount of time for the defense to prepare. And the fact that Ann Taylor is not prepared, and she's claiming she's not prepared, that'll be no doubt one day in appeal, depending on what happens during this case. But anyway, folks, we're going to talk about that today. So hold on to your seats, hold on to your hats. You're about to enter true crime from a police perspective. You're about to enter the off-the-cuff zone, the police off-the-cuff zone. There has to be some common sense.
They were the ones who called 911 to get him help, and now they're calling for change.
And now a word from our sponsor. BetOnline continues to be your number one source for all your sports betting action. And with baseball in full swing and football season around the corner, BetOnline has more ways to stay in on the action with the latest odds, news, and scores, even live in-game betting. From Major League Baseball, UFC to tennis and NFL futures, BetOnline remains your choice for sports wagering info. In between games, head over to the BetOnline Casino with all the top Vegas-style games, including poker and live casino. Head to the website today and take advantage of the industry-leading VIP program with level-up bonuses and weekly cash boosts. BetOnline, the game starts here. You know, I'm so excited to get this report in, because it was what we were all sort of hanging on. What was going to happen next? How was Judge Hippler going to rule? And we all had several hints based on the judge's demeanor and what he said in previous hearings. But this is the piece de resistance. That's my little bit of French. Anyway, joining me in the show today is retired NYPD Sergeant, professor at Alberta's Magnus College, attorney. Welcome to the show, Professor Mike Geary. Welcome, Mike.
Good to see you. Good to see you. Thank you for having me on.
Absolutely. You know, Mike, this is not a surprise to us. Everything that was predicted, that we predicted in regards to the rulings, came true. So, you know, not to pat ourselves on the back, but every once in a while, it's good to do that. Judge Hippler ruled no continuance, right?
That's right.
No invented perpetrators,
Right.
you know, and the jury they'll be moving forward, picking the jury, and this trial will commence on August 18th.
Yeah, Bill. Judge Hippler was right. He got it right. The state argued that to allow Ann Taylor to have her continuance would just be actually making the trial and the timing of the trial at the mercy of public information. And that's not fair to Bryan Kohberger. It's not fair to the community. He's looking at, when we start in August, he's looking at almost 2 years and 2 years, 9 months behind bars. That's not the way we do things here. So Hippler's absolutely right. You got to go with this trial. It's too late to turn back. You got to go. It doesn't serve anybody any ends of purpose to delay this anymore. And so that was fantastic. And then he goes on in his decision. He goes on and he talks about the alternative perpetrator rule. But excellent that the case is going to start pretty much on time.
You know, Mike, if I could just read a little bit from the brief. The state previously moved in Lamine seeking to preclude defendant from offering or arguing alternate perpetrator evidence without first satisfying the applicable evidentiary standards. In accordance with the court's subsequent order in the motion, defendant filed his office of proof and evidence in support, identifying 4 individuals as potential alternate perpetrators. The state objects to the presentation of this evidence at trial, arguing it fails to satisfy the standard under State versus Meister. Defendant conceded at oral argument that, at this point, his proffer is not sufficient to pursue an alternate perpetrator theory at the outset of trial, but requests latitude and cross-examination of the state's witness to try to establish additional evidence to satisfy the Meister standard. Now, Mike, I mean, I think that's a fair ruling. I mean, how would you introduce other perpetrators with no evidence of it? You're just going to bring up 4 names? What would that do to a jury if that was allowed?
Billy, Judge Hippler's absolutely right on this. She has failed to show in papers, motion papers, that these 4 that she named have any real connection whatsoever to this case, other than they're just random people in the community that happen to know these girls and Ethan, and they may have been seeing each other during that time period. None of them drive a white Hyundai, and they all 4 submitted to a DNA analysis, and there's no connection whatsoever. There's no witness connection. There's no car connection. There's no DNA evidence. And he thought that'd be very prejudicial to the state's case by allowing her to introduce these 4 names to try to throw off the case against Kohberger. She didn't even have anything to build a foundation upon other than what he said is just speculation. And you can't have that. That's not fair to anybody named. But she can question all of the investigators as to the thoroughness of their investigation. She can do that. She certainly can, and she certainly will. But this idea that she's going to develop an alternative suspect theory, not now before the trial begins, but during the trial in the state's case, through her cross-examination of witnesses, come up with information to substantiate an alternative suspect claim. No. At the outset of trial, you must have satisfied to the judge's agreement that you have some foundation. This sounds very much like her alibi. Remember the alibi witness? She couldn't name anybody, but she said she would develop an alibi witness through cross-examination of the state's witnesses. Judge shot that down. So therefore, she actually has no cards to play. And I think Hippler was pretty ticked off. If you read the order, the motion order denying her motion, you can see Hippler really has lost his patience with Ann Taylor.
Well, he cited a case, State versus Meister, and that gives him case law behind him in order to turn down this request. But if too much latitude is given to the defense, then they're bringing in things that have really no basis in proof, no basis in truth. And to allow them to do that would severely compromise, I believe, the jury and compromise the prosecution, their attempt at presenting a solid case vis-a-vis the evidence.
Yeah, Meister is that Idaho case that Judge Hippler relied on as precedent. He said, we're going to follow this precedent in this state. He said, if Meister gives the judges guidance on how to rule on these kind of issues, and according to Hippler, he writes from Meister, if the defendant proffers, meaning offers evidence, which tends to mislead the jury that another person may have committed the crime, or the evidence that she claimed, things that she claimed as evidence, is not relevant because it doesn't tend to make the defendant's involvement more or less likely, which is what evidence is. It's well within the judge's discretion to withhold that offering because it may tend to mislead the jury. So Hippler is well within his rights to do this. If there was anything like even a scintilla of evidence, again, evidence, not just suspicion, evidence, some objective evidence, he may have ruled the other way, but absolutely not in this case. He told her several times. We saw this when they were televising her motions and his responses, that he was not satisfied whatsoever with what she had preferred, meaning offered as foundation in her documents. And they even had a closed door with the public out of the courtroom, closed door session, and there she couldn't even produce anything that was objectively, rational to claim that these other people were connected. Hippler did the right thing in shooting her down.
Mike, if you look at the prosecution and the defense, and you pretend that you're watching a card game, and you're looking at the poker faces of each side, you could see that the prosecution is not even breathing heavy. They're not perspiring. They're not nervous. They are totally confident in the hand that they are holding. Whereas if you look at the defense as if you were watching a poker game, they are all over the place. They have deuce high,
Right.
in their hand, and you could tell by the outlandish things that Ann Taylor has tried to put before this court that she is really grasping at straws. As we said a million times, she's throwing the spaghetti at the wall and it's falling right to the ground. Nothing is sticking.
Nothing is sticking at all. If you watch a movie and you see one card player just sitting there, very, very placid, that's Bill Thompson. You see another one across the table and they're sweating, they're stammering, they're coughing, they're scratching, they're shaking. That's Ann Taylor, because that person has nothing but bluffing. That's all they've got. They don't have any cards in their hand. That's a shame, but that's the way it goes. Sometimes you get good cases to argue as a defense attorney. Sometimes you get cases where the police did an outstanding job, and this is that case. So therefore, she didn't have a lot to begin with. She got dealt a bad hand of cards, and she's doing the best she can. But all she's got really is a bluff. When you can't sit there and tell me that you have somebody to give an alibi that could actually offer an alibi as to where he was that night, or you don't have any real evidence that there's an alternative suspect, you've got nothing here. She lost the DNA argument. She lost the knife argument. She's lost all those arguments. There's really not much for her to play, but play it out, do the best she can at trial, try to show that to the jury that perhaps the prosecution witnesses, like the law enforcement investigators, didn't do a thorough job. That's her right. She can do that, but that's how she's going to make her arguments to the jury, not throwing in an alternative suspect or an alibi. That both of those are groundless.
Folks, what we're going to see here from Ann Taylor is a lot of attacks on the evidence, a lot of attacks on police procedure, and the big attack is going to come against the FBI and how they processed the DNA evidence via investigative genetic genealogy through using public sites like GEDmatch, and the other one was MyHeritage, and claiming that they violated the law in failing to follow the procedures of A, the Justice Department, and B, MyHeritage and GEDmatch, where they built these family trees. That is a huge area that Ann Taylor is going to attack. And whether the jury buys it, I mean, it's already been ruled by Judge Hippler. It's coming in. It's
Right.
legit. They did it right. Whether they got a warrant or a subpoena and able to use the public sites like GEDmatch and MyHeritage, the evidence is in. So I don't know how she may just try to create doubt and say, look, the FBI stepped all over my client's rights. That's what she may try, Mike.
Yeah, there's an old adage for lawyers. If you have the facts, you argue the facts. If you have the law, you argue the law. If you don't have the facts of the law on your side, you just pound the table and call the other person a scoundrel. That's what she's going to do. She's going to attack really hard on cross because she doesn't have anything really that she can offer when it's her turn for Kohberger to present his defense. You know, she doesn't really have that much to offer, because by the time she gets to do that, there will be this truckload of evidence already presented. And for her, it'd be an uphill climb. And, you know, this kind of case is the kind of case where normally, under normal circumstances, you and I have talked about this, that if there wasn't the death penalty on the table, there might be an offer and maybe an acceptance of a plea bargain. But I don't think so. I keep my fingers crossed, but I don't think so. She doesn't have any cards to play.
Absolutely. This is from Banfield.
Of Idaho, Bryan Kohberger and the quadruple murder case. I have been waiting for this decision, and it looks like his lawyer got a little bit of a reprieve, albeit just a little one, like a week-long reprieve. But the judge is giving Kohberger and his lawyers an extra week to sort through some of their issues and some of that discovery that they have felt like they're buried under, right? And even though the trial is still set for an August start, it's 1 full week later than originally scheduled. The judge did deny a couple things, like denied the all-out request for a full-on delay, like weeks or months, writing that Kohberger had not demonstrated that a major delay was warranted. Also said that a more thorough life history investigation isn't necessary, nor is the pretrial publicity a reason for a delay. And what might be even worse for Kohberger, in a second ruling, the judge has also denied Kohberger's request to present alternate perpetrators in his trial. You know that theory about, I think those people did it. The judge said that the evidence that he and his lawyers presented to link 4 other individuals to the crime is, quote, entirely irrelevant. Ouch. So we're going to keep you posted if anything else crops up. But for now, jury selection scheduled to start on August 4th. Testimony now scheduled to get underway August 18th.
Thank you for watching. Subscribe below and download our news.
So I'm sorry I didn't get him off the screen fast enough. I mean, he ruled in favor in everything in the prosecution. No continuance, right? No alternate suspect. We are moving forward. We are moving forward this case, and many people, you know, there's a lot of people that follow this case that believe that Kohberger is innocent. There are those out there that believe that. And they will view Judge Hippler's rulings as these pro-prosecution. It's corrupt. It's this, it's that. They're crazy, though. Those people are nuts, you know. Judge Hippler, his rulings were based on the law. He even cited the case of Meister and not allowing an alternate suspect. You want to allow then have some evidence. Don't just come up with 4 names. And then the jury is supposed to listen to that as if it's credible. When this case first started, Mike, on November 13th, 2022, when the murders occurred at 04:10, 04:12 in the morning. After that, for 6 weeks, there was hundreds of suspects. Remember? Oh, it's the boyfriend. Oh, it's the guy at the food truck. Oh, it's this. Oh, it's these 3 guys that were walking around drunk. Ridiculous. That's why the thing, evidence, what makes other things apparent? That is evidence. And that's what you need to charge someone or to bring someone's name into it as an alternate suspect, not just pulling something out of a tree and saying, oh, let's try this guy. Maybe it'll create doubt. That is not fair. to the prosecution. If you have real doubt based on evidence evidence, then bring it forth.
And Bill, she can't really complain, although she has many times, about the terabytes of information, and she's overwhelmed. I just want to read just a quick sentence from Hippler. He said, defense counsel has robustly litigated this case, retaining approximately 24 experts and a full mitigation team, engaging in extensive motion practice, which means making motions. These actions belie his counsel's ongoing and ultimately empty discovery complaints. Without more, the court can only conclude that defense is using the volume of discovery as a tactic to delay the proceedings simply for the sake of delay, rather than any legitimate threat of prejudice to the defendant. So he was so mad at her that he rightly pointed out to everybody, she had, it wasn't just her and an assistant, she had experts, and the state has provided her with a lot of money, a lot of resources, and we're still getting delays because she's overwhelmed. Too bad. It's the 11th hour. It's go time.
You know, Mike, what I say to that is, I say this, what you see on the screen there, Madison Mogan, Kaylee Gonzalez, Zana Knodel, and Ethan Chapin. They're dead. All four of them were murdered, brutally murdered in their house. And although Bryan Kohberger is innocent till proven guilty, he is going to be on trial for the murder. Let's not forget that. A quadruple murder of these four young college students. So when Ann Taylor, 2.5 years into this, says, oh, I need more time, thank God we have a judge like Hippler says, well, guess what? You're not getting more time, because these victims, they all have families, right? They all have people that love them. The town of Moscow, Idaho is still traumatized by this and will always be traumatized by this, no matter the outcome of this case. So Ann Taylor, too bad that you don't have enough time. Then you should have thought of that 2.5 years ago and requested more resources. But at the 11th hour, we're not sympathetic to you.
No, Bill, everybody, the idea of due process is for everybody. It's for the community. It's for the prosecution. It's for, and especially for the defense. Nobody should, no innocent person should ever sit in jail for 2 years and 9 months before their trial takes place. That is terrible. And so that's what part of the idea of due process. And for her to keep asking for the continuances, she'd have continuances going on into Kohberger's 3rd full year, going on his 4th year in behind bars. That is not the way it's done. Hippler understands he has an ethical obligation, just like she has, just like the prosecutor has, and due process demands that he be brought to trial. And whatever the outcome is, we will live with it, but he has to be brought to trial. It's not fair to anyone. There's no due process for the whole group collectively unless he's brought to trial in a timely manner. So time's up. She's got to get ready. When he bangs his gavel and says, "Are you ready?" she has to stand up and say, "I am ready." That's the way it goes. That's the cold, hard fact. If she has to work 24 hours a day, 7 days a week for the next 8 weeks, that's the way it goes.
100%. This is from WKREM.
Learned when the trial for the Moscow murder suspect Bryan Kohberger will begin. An Idaho judge decided today it will get underway 1 week later than planned. KREM 2's Connor McAvoy has been looking into this ruling today and talked with a former Idaho attorney general about the change. Connor?
Well, today we learned the judge in this case denied the defense's motion to continue the trial and said opening statements will begin on August 18th. He also ruled against using evidence the judge writes is unsupported speculation. Police arrested Bryan Kohberger for the murder of 4 University of Idaho students in December of 2022. His defense team argued it should be delayed after a recent Dateline episode revealed information about the case that wasn't publicly available. Prosecutors argued delaying the trial would not do anything to solve the problem. Judge Stephen Hippler wrote prolonging the trial only creates more media opportunities about the case. This led to the decision to only delay the trial by 7 days, something former Idaho Attorney General David Leroy says is nothing new for this type of case.
So a 1 week delay or adjustment in starting times is not significant for a case that has waited 2.5 years for trial.
Leroy says the 1-week delay, while not significant, is still important in taking the time to select an objective jury.
And because of the high-profile notoriety of the case and the local connections of the case, it indeed may take some time to set a jury.
The judge also ruled the defense cannot use a list of 4 alternative suspects as evidence in the trial, but can use it to cross-examine investigators on the case. Leroy says that decision was a wise one.
Their cross-examination is not foreclosed, but an argument based on suggesting that one or more of any particular individuals may have been an alternative perpetrator will require something much more than the mere suggestion of a name that somebody else lived close by.
With the new trial date set, Leroy says Judge Hippler's rulings in the case are promising a long-awaited trial gets underway sooner than later.
There's an old saying that justice delayed is justice denied, and the defense has had a considerable period of time to get all of its ducks in order and its experts lined up, its understanding of the evidence. And the judge so says in this order about going forward now with only a slight adjustment.
Prosecutors say they intend on seeking the death penalty if Kohberger is convicted.
So there you have it. I mean, it's, one of the things that I totally didn't fully understand was the Dateline NBC documentary, the book coming out by James Patterson, another book came out by Howard Bloom, and the primetime documentary. The court, the judge cannot control media because they have freedom of speech. They can broadcast what they want. They can publish books. They could say what they want. However, from the judge's perspective, he can try to find out who leaked the information to Dateline NBC. But will that really, in the bigger picture, Mike, affect the fairness of the trial? Will that affect it?
Bill, I don't think so. We've had other trials of the century where they've had all kinds of publicity beforehand and during and after, analyzing things to the umpteenth degree. And so therefore, we did it. Whether or not people think everything turned out fine, that's an individual idea. But you can do this because we're better than that. We're not going to hold ourselves hostage to the First Amendment. That allows people to say whatever they want. But remember, the jurors are sworn to base their decision based only on what they hear during the trial, what is actually offered as evidence or counter arguments to that evidence. So therefore, they take that pledge to be fair to Bryan Kohberger and to the state. So therefore, you got to do it. And Hippler did the right thing because you can't delay. Because there'll never be a time in a case where there's going to be 6 months, without a leak. The leak is of a lot of the things that were leaked is just a little bit more dramatic telling of things that we already knew. So it wasn't like they talked about they found Kohberger's fingerprints also at the place, and they found the knife, and there's video of him entering through another Ring camera, that things that nobody really knew about. A lot of it was just a little bit more dramatic, more intense of what we already knew. But it's in the long run, all the evidence had been gathered, and turned over. So I don't think the special has any real effect whatsoever. That you find someone who doesn't really have any idea about this case whatsoever. There's probably some people out there, but I don't think too many of them.
So to recap, folks, Judge Hippler has ruled no continuance. This case is going to go forward on August 18th. The jury choosing of the jury will proceed. Alternate perpetrator, no good. Out. Threw that out. State of Idaho versus Meister. He cited that case as the reason why. And pretty much everything else. The alibi, I think that she can cross-examine maybe to create an alibi. I don't know if she can really, if too many people, now that the alternate suspect theory was thrown out, I don't think too many people are going to believe the alibi about driving around at 4 a.m. looking at the stars. So she may even abandon that as a strategy. Anyway, folks, if you're not subscribed, hit that subscribe button, hit the like button. If you want to contribute to us, we have a Patreon with 4 different levels. We also have a YouTube channel membership with, count them, 5 different levels. We appreciate all of our fans, friends, and subscribers. You know, it goes so fast, but this is really important information that came out today. And now this trial is going forward, and let's hope it goes smoothly and Bryan Kohberger gets a fair trial, and we will see what the outcome will be. Your quick final thoughts, Mike.
Bill, I think people should be pleased that this case is going to finally come to trial, whether you're a pro-Berger or not. You know, everybody needs to have their day in court. The former attorney general said it right. Justice delayed is justice denied for everyone, victims and accused alike.
100%. Folks, thank you so much for tuning in. On behalf of Police Off the Cuff, I'm Bill Cannon, and with my co-host, Professor Mike Geary. Have a great day, everyone, and God bless.
One episode just ain't enough.